used to conduct our business and gather our information, there's a spotlight being shone on that now. And we're under increased scrutiny from counterparties to litigation, from the courts to the regulators, and so on. All of the things that I've listed up here are all cases that I have either advised on, seen, heard about from the wider investigation industry. And those cases are becoming more important because there's a growing number of uses that investigators have to us litigators. All of the things that you see here, from gathering transactional due diligence to doing intelligence work pre-action against different witnesses and counterparties in litigation, to just identifying where someone is and where we might be able to find them so that we can serve process on them, gathering intelligence about witnesses, and then at the heart of it all, gathering evidence for use in litigation. Given that there is probably a role for a private investigator in almost every facet of litigation these days, it's no surprise that there was going to come a time where the eye of the litigator would turn on the investigator. And the cases that we've seen come through the English courts this year mean, I think, that that time is now. The general risks that are being faced are not limited to just exposure, which probably used to be the thing we were all most concerned about. The worst thing that could happen would be that someone you were investigating would find out you were investigating them. That's not the worst thing anymore. And I'd like to cover a few cases that we have seen in the public and that the panel is going to talk about, just so we're all on the same page. I think it's worth, as a starting point, because I know there are people in the audience who are not from this jurisdiction, to say that in the UK we don't have any licenses for our private investigators. There have been various attempts over the years. The first of those was in 2005, when the Security Industry Authority decided that it was going to try to license private investigators in this jurisdiction. I was part of the working group that tried to create a definition of a private investigator in 2005. And although the Security Industry Authority managed to license virtually every other part of the security industry, they failed completely trying to create a license for private investigators because there was no common agreed definition of who was or was not a private investigator. I exited the working group when I spent 4 hours sitting in a Hilton down in Slough listening to a debate about whether or not psychic investigators were deemed to be private investigators, and decided that I had done my time for public service. So we're left with a sort of incomplete and unsatisfactory set of statutes that are all there to govern civil society. They're not geared towards private investigators. Private investigators follow all the same laws in this jurisdiction that the general public do, which means we have to create our own rules of conduct. And because we've all created different rules of conduct, that leaves the opportunity open for litigators to come in and allege that there has been impropriety on the part of the investigator that should have an impact on the litigation itself. The first example of this litigation dates back to 2006. So there was a fraud case that was running through the civil courts here, and the defendant discovered in the course of discussions with the Information Commissioner's office that a private investigator had obtained his personal bank details. This was confirmed for him when the claimant in the fraud action used those same bank details in the litigation. So the claimant, whose name was Hughes, brought an action against the law firm for disclosure of who they had hired to obtain his banking information. The firm was Muchin, and the private investigation firm was called Katten. It was discovered that a couple, Sharon and Stephen Anderson, had been working for Katten and were using blagging to get banking records. Looking back on this now, it seems sort of sweet and innocent, doesn't it? From a decade in the future, that all that happened was a little bit of blagging of bank details, given the cases that we're going to look at in a moment. The Andersons were prosecuted, Katten was held liable in the civil courts, and the Mishkon's partner, who had commissioned the work, left to found his own firm. I have no idea whether it was by consensus or otherwise. But as time moved on, the actions of private investigators has drawn more attention in the criminal courts. And these things were all connected as they unfolded here in the UK. This was, at the time, the trial of the century. There were 14 defendants charged in the first trial, an assortment of journalists, editors, and private investigators. The private investigator who was at the heart of it all pleaded guilty almost immediately, but the editors and the journalists fought the case. Some of them were convicted, some were acquitted, but ultimately it exposed a significant amount of detail about the conduct of private investigators and investigative journalists in this country. And it started a almost nationwide debate about the nature of privacy and what could and could not be done in terms of obtaining confidential information. Again, looking back now, that almost seems sweet and innocent for the time. In 2019, we've had this case already this year, Saab and Dangate Consulting. And if you need a better example of the risks that private investigators face, I don't think you could find one. Dangate Consulting were an investigation agency that were hired by a bank in Cyprus to go and conduct an internal investigation into allegations of money laundering. Over time, the investigators were looking into a large number of allegations, and over time there was a little dispute about fees and about the scope of the investigation. And I might need to make it clear that I'm not suggesting for 1 minute that there was anything retaliatory in what happened next. But I need to make it clear that I am not suggesting there was anything retaliatory. However, after Dangate Consulting had this dispute about fees, there were disclosures made to the authorities in Cyprus, and there was some contact with an investigative journalist called Marc Hollingsworth, who was approached in, I see two journalists in the audience giving each other a secret smile. I love that. I can see from up here even. Oh, sorry, 3. Oh, should we just have a show of hands? All right, fine. In any case, a journalist called Marc Hollingsworth was contacted as part of this. The court didn't happen to find whether or not any disclosures were made to Mr. Hollingsworth, but there was broad consensus in the judgment that he had been contacted. What was the upshot? The investigators thought they had a justification that it was in the public interest. The law enforcement bodies in Cyprus had asked specifically for those disclosures to be made to them about potential money laundering allegations. Despite this, and despite having received a direct request from the Cypriot authorities, the English courts held that the investigators had breached their contract to their client and they were held liable. In other words, even if you think you are doing the right thing and you are responding to a request from law enforcement, if you make a disclosure where there's a confidentiality obligation in your contract, you could find yourself liable in the English courts. I think that one surprised everybody who was looking at it, and I know for a fact it surprised the defendants. And then what happened next? In September, there was a case that got a lot of attention in the English courts. And although this is just one case that's been filed, it's the latest in a long-running dispute between various parties. So I need to tell a little bit of the backstory. This claim is from a couple called Neil Gerard and his wife. Neil Gerard is a partner in a law firm called Deckard. Neil Gerard had a former client called Iain RC. And he was investigating Iain RC at their request back in 2011. Later on, there was a fee dispute. I think this is becoming a hallmark of these cases. Iain RC suggested that Mr. Gerard was ramping his fees and inventing new things to go and investigate in order that he could generate more fees for his law firm. Equally, Iain RC also suggested that Deckard had had secret conversations with the Serious Fraud Office in order to get the SFO interested in the case, also in order to ramp their fees, it is alleged. Meanwhile, in 2019, this claim is launched by Mr. and Mrs. Gerard against an investigation agency called Diligence. I give all that backstory to show that although Diligence is the defendant to this claim, they are not the stars of this show. They are the investigators who were hired by litigants who are engaged in a much longer-running, much broader dispute. And if you doubt that, look what happened next. This is an action that followed shortly after. Iain RC against Marc Hollingsworth. I feel like I've heard that name before. In any case, I have it here. A 65-page claim, Iain RC against Marc Hollingsworth, which I'll leave right there, just in case. This claim sets out a great deal of detail about the relationship between Marc Hollingsworth and Neil Gerard. Again, Hollingsworth is the defendant to this action, but he is not the star of the show. So all of these cases, and I'm going to stop there in terms of my legal summary and case history and open it up to the panel. All of this leads me to conclude that this is a time of extreme risk for investigators, for people hiring them, and for anyone who is engaged in this industry. Because litigators like myself, like Bernard, are looking for any way that we can to gain leverage in litigation. And if attacking not the evidence, but the method of its collection is the way for us to obtain that leverage, then that is the action we will take. So if I stop there and hand back over to Bernard for discussion.
Brilliant, thank you. I confess I don't know the details, but I'm sure one way or another that slide show will be available to people. So next I'm going to go to Joana. I'm pretty sure the answer to this is not psychic investigators, but anyway, in light of all of those difficulties that Polly has set out, how on earth do you do your job today?
I mean, it's definitely increasingly challenging, and that's why, the bottom line is I think we have to be increasingly responsible about the way we conduct our work. We have to have a much greater focus on a longer-term strategy, and we have to be working in increased closer coordination with counsel. But I think in order to answer this question properly, we probably need to take a few steps back and kind of raise a few distinctions which kind of help answering this question. The first one is really the nature and the identity of corporate investigators. You've got an incredibly broad industry with a number of different actors that are doing, the same and different things. You have to think that on the one hand side, you've got the Kralls, the FTIs of this world, the big accountancy firms, PwC, EY, all have corporate investigations departments. And this goes all the way to boutique investigations companies like Raedas and Vantage, to the gumshoe investigators that are, doing, say, surveillance. So you also find now that you have a number of law firms that also have their intelligence and investigations arms, and also litigation funders that are doing this kind of work. So what you see here is a lot of different interests and a lot of different ways to interpret the client's needs. The second distinction is the use of the product of these investigations. And here there's a distinction to make in terms of how the industry is traditionally split. And there's a lot of investigators in the room that know, we sort of split this in two different tempos, essentially. The pre-transaction work, which Polly has raised as well, for which the objective is to gather insight into the reputation, the integrity of potential business partners, versus the world of disputes, which is what Gretchen and I focus more on, where you are focused on the gathering of evidence and the support of litigation arbitration. The key distinction here is on the one hand side, you're talking about hearsay and rumor, which can be really important. It's something that is really valid in the context of a due diligence exercise. The objective in this kind of exercises is, as Polly also mentioned, to avoid harming the reputation of the people you're investigating, but also to keep your interests closed, not known. In our case, we are thinking about the usability of the information that we're generating. And this is a really key distinction, because when we are gathering this information, we're having to think about how is this going to be used? Is this going to be used as evidence? Is this going to be used in a PR campaign? Is this going to be used, across another strand? So this is another key distinction. The third one comes to how this evidence, or how this information, let's keep it like this, is gathered. And I think here, it's important to raise that, we live in an era where, there's high digitalization and availability of public records. You've got nowadays, very complex AI softwares, that are aggregating property, corporate, all sorts of media information, and the bigger the company, I will add, the more resources you're going to have as well. So what you find is we live in a world, the investigators live in a world which is packed with open source intelligence specialists. This is a really crucial distinction because, open source, it goes beyond doing some clever Googling, and there's an element of being able to know where to pull those records. We work across a number of jurisdictions, knowing what's available, knowing how to get it, and knowing how to do it in a cost-efficient way. And the other element is being able to question these records and being able to say, how can one go further with what's obviously available? And we see this a lot with, like an example is the land registry in the UK. One can go onto the website and pull the records that are available there, but if you actually go to the office and then start questioning and pulling from more, you will get a lot more information on transactions, on historical ownership, on all of that. And this is a very basic example for one jurisdiction. But the reality that we kind of face is, the disputes that we get involved with are really seldom solved in, sitting behind a desk. So we are always trying to think about the people that are going to help us understand a bit more about what is happening. They help us tell some kind of storyline, have a storyline. Again, the key distinction to make here is that, and here we're talking about source work, and, Polly has also touched upon that. And the main distinction here is that not all corporate investigations firms do source work. Some, like I said, specialize in open source. The majority of the ones that do outsource that work, and a few do it themselves. In my case, we primarily do it ourselves. And there are main reasons for it, which I think start answering your question. The first one being, you have much greater control over the information that you're getting. If I am speaking to someone, I will get the information firsthand. I will hear it. I will be able to push for questions. I will be able to gear the conversation where I want it to go. And it's something that will be much more helpful for my case in being able to know how I'm sort of managing and listening to this information. The second one is I have control over how I approach people, and I will know if I'm going to have to use that, if that person might potentially become a witness on my case, I will know that I'll have control over what I am telling them I am doing. And the third one is I can confidently deliver this to the litigators and tell them truthfully what has been done and how it's been done. So this is probably, in terms of how we operate, this is where it really requires a much closer cooperation between counsel and the investigators. The investigators have to be truthful about how they obtain the evidence.
Sorry, can I just weigh in for a second? The problem with these new cases isn't that there are corporate investigators doing their job. And in most of the cases, bar one, no one was raising an issue about the method of the conduct of the materials. It is the fact of investigators looking into these subjects that is now being used as a point in litigation. The invasion of privacy, the breach of confidence, that is a new tortious cause of action that is being used by litigators. So the sort of capabilities of the investigator almost become a little bit redundant. You can have done it as perfectly as possible. It is the fact of you looking that becomes a cause of action. And that's what I think is critically different in the current environment.
And that's something that we have to be increasingly prepared for, because one of the, and we're going to touch upon this point a bit, is that we know that we are increasingly a pawn in litigation tactics, and that the work that we are doing is going to be much more under scrutiny going forward. So we have to be, sure of what we're doing, how we're doing it, and being able for it to stand, because the reality is these are really hard-fought disputes. And these disputes are not going to be solved behind, let me check the kind of, pull the records that are going to show me who owns this company. This is just not how it works. The reality is these days, if people want to hide assets, they're going to hide assets. If people want to hide a purpose, they're going to hide purpose. Our role is to be able to find ways in which we can, ensure that we are gathering this information as, lawfully and, to the best of our abilities.
Okay, well, we'll come to the justification for why you do your work in a moment, but I should not pick you up. You may not want to be picked up, but anyway, we can come to it later if you want. But you mentioned usability of information, and I just wonder if you could expand upon that a little bit. Do you mean the weight of the information? How good is it? Merely a rumor, or is it a document, or what do you mean about that phrase, usability?
I think it's all of the above. I think we have to be thinking about disputes in much broader sense than they have been thought until now. You know, the disputes aren't necessarily only solved inside a courtroom. And a lot of our work is looking to produce evidence that can be used in a courtroom and that we can, you know, potentially testify to its origin and provide counsel with the reassurance of where it was obtained. But there are situations where we're going to come across or where we're going to be given information, we are going to find information that might not be readily, immediately admissible. So there we're going to have to be thinking about, you know, is this information admissible? How can we make it admissible in the event that it is not? Or C, just discard it completely. But it's thinking about, if it is not, you know, are there other strands? Is there a PR angle that we can maybe use this information in? Is there another pressure point that we could maybe deploy to essentially gear?
So it's how you use the information.
Yes, how we use it.
All right. So coming on now to, I think, Polly's point about justifying justifying the actions you take. The Gerard versus diligence case refers to the GDPR stuff, and there is some stuff on your slides. I'm just seeing if I can bring it forward. So Polly's slides do cover that off as well. What I'm going to do is ask Gretchen as an investigator to explain to us what the investigator's obligations are under GDPR and how do you address those obligations in actual practice.
Sure. Unfortunately, this is probably the topic that investigators these days like to talk about the least because it's such a relatively new regulation that was not intended for our industry, but yet we still have to ensure that we're completely compliant with GDPR or face some very substantial fines that I think are outlined on Polly's slides. We at Vantage, we sought legal advice and a consultant to implement policies and ensure that we comply with everything that GDPR sets out. We have an internal data protection officer who oversees our compliance. We have set specific standards for retention of documents. When a project is over, we in accordance with the client, we will destroy data. What is, very onerous is that it's hard to control even what happens within your own organization. So an individual who submits a subject access request is entitled to any document, email, in which that person's name is contained. So it can include other materials that you have no idea have even been circulated within your firm. So it becomes a much bigger issue than what it seems to be on the face of it. And discussions with other people and other colleagues in the industry, I think quite a few firms have received requests. We, as a firm, have received one. I think I've spoken to a few others, and they've received, I think one firm, has received more than 10. And there's a question, and still a gray area, as to how you have to respond, whether we as investigators are data processors or data controllers. So in contracts with clients, you can provide that the client, as long as it's set out in accordance with GDPR terminology, that the client is actually the controller. So if the investigative firm is the processor, then you can just simply respond to the data access or subject access request and say, we process your data, you need to ask the controller, but you will have to identify the actual identity of the controller. I think that overall this becomes, going back to the theme of us being a pawn in a larger chess game, I think GDPR adds to that. This will allow individuals who are subject to large or part of large legal disputes to send just blanket requests to any intelligence firm that they think may be acting against them. It will then potentially yield information, some clue as to what the investigative firms hold on these individuals. The knowledge that these firms are actually working, on a matter will allow lawyers to now include them potentially in litigation or in discovery requests. And it also serves the purpose of just putting pressure on the adversary and on the firm that's doing the work, because when you're no longer in the shadows, for lack of a better term, you obviously feel a little less comfortable with what's happening. And certainly as much media scrutiny is now surrounding the industry, with not even just with these legal cases, but the series of articles. The Black Cube articles are very prominent more recently. It's definitely a topic. Any the use of an investigative firm generally is currently a very relevant in the Atlantic. There's a series of
New Yorker, New Yorker.
New Yorker. Sorry.
What do they say? I haven't seen
We'll send them to you.
They essentially outlined in very a lot of detail the work of a quite aggressive investigative firm.
Do you draw any conclusions from that?
In what sense?
About whether or not there's likely to be greater scrutiny of the industry?
I wouldn't. I think that as a general principle, I wouldn't, for my own firm, want such publicity. We also don't necessarily take the same approach that Black Cube takes in a lot of its work. According to the media, I have no firsthand knowledge of how Black Cube conducts its operations, but it's something, if you haven't reviewed them, you'd definitely find it of interest.
I think the thing about the DSAR is that it's a useful tool, but it's not the only tool. So I did not have the benefit that Gretchen has had of waiting to see how many DSARs rolled in after GDPR was passed. At 4:30 p.m. on the 24th of May 2018, my client got served with a GDPR breach notice. So we rapidly had to upskill in what was likely to be alleged by or against investigations firms when GDPR was in play. And the breach notice arose as a result of an investigation that my client, which was a bank, had commissioned into a fraudulent debtor. And the investigation agency had been instructed before GDPR had come into play. And in fact, the investigation report was only obtained by the defendant having bribed a bank employee to get it. It didn't matter. We still had to defend the breach notice. And we had to defend the basis on which the materials had been collected. It became hugely problematic, but also hugely instructive as to how GDPR was going to be used as a tool. I mentioned before that the DSAR isn't the only mechanism. If you want to take a very reductive or even restrictive approach to a DSAR and you're an investigator, and I have had these responses when I've advised clients to bring them, where the investigation agency simply writes back and says, oh, we have no personal data, and we're not the processor, we're not the controller, you'll get no joy here. There are court orders that can be obtained to force compliance and to force detailed compliance, and these come with much more rigorous penalties. So it's not as though the DSAR is the end of the game, that's just the cheapest and easiest way for the target of an investigation to get stuck into the materials that are being held by their counterparty.
Well, I mean, one issue that arose as part of the advice that we received when before GDPR kicked in was, because the majority of our work is in the context of litigation, that, there would be majority of situations, even though the advice was fuzzy, we would be protected by legal privilege. I mean, how do you interpret this? And
Was it a gray area?
It was not a gray area, it was a fuzzy area, but...
Fuzzy area, fuzzy gray area.
I think all GDPR seems to be a gray area no matter who you talk to. Most lawyers, are still figuring it out, so I think it's just a general gray area. Yeah.
Especially when the commercial purpose of our business is to gather information. It's a hard one to
that's the
balance.
that's the critical thing, isn't it? And this is where we most commonly get called in now in a way that I didn't used to. I mean, I used to be an asset tracing lawyer, not an investigations lawyer. And my relationship with investigators was simply to instruct them and to receive the materials that they obtained. Over the last year, in fact, since that GDPR breach, happy, very horrible Friday, there has been an endless stream of requests from the people whose client I used to be, who are now looking for guidance and instruction, because GDPR is designed for the general public. As I said in my introduction, there is no special law for private investigators. And the general approach in GDPR and the general approach of data privacy, data protection lawyers is no. That's the most common answer. Can I do it? No. Can I get that? No. So you have a whole industry that is geared towards and focused on the gathering of information, and a data protection, data privacy regime which is all geared towards stopping you from gathering information. There is a way to lawfully conduct investigations, whether for litigation or for any other lawful purpose under GDPR. It's about documentation. What slide is up there anyway? Can you go back one? Yeah.
Now you're testing me.
There is a way to conduct lawful investigations under GDPR and the new California privacy regime. It's about documentation. It's about noting carefully why you are doing your investigation and why you believe you're entitled to, so that when the nasty lawyers come along afterwards and say, we're going to bring an act, and I meant me, by the way, not Bernard, he's lovely. When we come along afterwards and say, we're going to rope you into this, as a piece of satellite litigation, then you are able to say, no, you're not, because I have gathered the information I was entitled to, I justified it, and I made all the proper documentation as I was conducting my inquiry. So it's not just about protecting the admissibility of the evidence you're gathering, Joe, it's also about protecting you from suit and liability.
No, I understand, and I think what we've done, and like Gretchen, we try to consider these points at the start of cases, and I think the main point is proportionality, because we have a case log, a legitimate interest case log that we fill in at the start of each case, and where we look to answer some of these questions. What is the legitimate interest that we have in addressing this investigation? Can we do this investigation any other way but collecting data in this way, and in balancing the rights and the freedoms of the individual versus that of our own? But it's pretty much as far as we go, and I think the difficulty is the nature of investigations themselves, and particularly the complex disputes that we tend to get involved with. They can take you anywhere, and you constantly have to be reevaluating this. And I think probably that's the advantage of working with you, because you probably kind of keep reminding the investigators you work with, you have to be thinking about this.
Awful. But do you two feel more exposed now, given the cases that are making their way into the public eye and into the media? I mean, I think espionage kind of carries a little bit of a saucy note to it. Do you feel more concerned now than you did before?
I personally don't. I was going to come on to this a little bit later, but at the beginning of my career, I worked for Diligence, and I was part of the relatively well-known IPOC scandal, where I was part of the recruitment of an accountant, and the accountant alleged that he believed that I was from the CIA, and so it was a major piece of litigation in the Washington federal court. There was even some congressional review of it to some extent. I think even the FBI looked into it. So that was literally a year into my career as an investigator. So I'm personally not surprised. I think that was a lesson. It was a very educational experience that obviously you can't impersonate government officials, full stop, but even creating a fake persona like we used to do at the beginning of, where you would just print a business card and not even have a website, because it was still accepted not to really have websites, although Bernard would say that I don't even have a website, and I exist. But yeah, I think that I don't think I feel any more exposed just because of that initial experience, but definitely learned from that in a very dramatic way, that you have to conduct investigations in a very within the parameters of the law, full stop.
Well, that's a great segue into our next topic, which is the risks. It seems that all we've discussed is the risks. So we've discussed congressional hearings, we've discussed satellite litigation, we discussed GDPR. Joana, do you want to tell us some more risks that the corporate intelligence people face, and also, we'll start off with the corporate intelligence, then we'll talk about other people as well.
Sure, so I'll feel sorry for ourselves. I mean, the gathering of the information business is a really risky business per se, because the issues at stake, they tend to be really quite high. So you are sort of just the mere fact of getting involved with them, there is a risk of exposure. Probably the one that kicks off every case for us tends to be the management of expectations. And in the work that we do, I think investigators are often seen as some form of panacea that's coming in to basically solve the unsolvable. You were usually brought in quite late in the process. I mean, not usually, like increasingly earlier, but you're brought in quite late in the process, with a requirement for tomorrow. And that's just not the reality. Increasingly we have clients that, occasionally contact us for us to, ask us to do things that aren't in the public domain. What can you do that isn't available in the public domain? To outright asking us to do things which some might understand are illegal, others might not understand are illegal. The fact of asking, for example, for criminal records in the UK, I can understand that a UAE lawyer, for example, might not know that that's illegal. But, asking outright if you can get bank account information, yeah, that's illegal in pretty much all the jurisdictions I know. So there's the management of expectations of the clients, but also helping them understand, A, what's realistic for you to obtain in the time frames that they need it, and things that might not even serve their purpose overall. Yeah, I had quite a long anecdote, but I think probably the second risk that I'd raise, and I think this kind of touches upon us doing a lot of this source work ourselves, is the risk of blowback to the investigation. And Polly, you raised this earlier in one of the biggest risks was the other side finding out that you're being investigated. And I think this can, of course, really impact a case because, you might find that the opponents start moving their assets, they start changing ownership structures, they try to do things that are going to deter from the investigation. So I think it's, in these situations, because we do a lot of this ourselves, there's the possibility of giving the client the possibility to pull the plug, for example. So, I mean, in a case I was working on recently, I was given the information that a former employee of an entity that we were investigating, whose assets we were investigating, that he'd been fired. And you sort of think, okay, there's someone I can potentially approach. So I called him, and and I told him who I was and what I was doing, and sometimes you just be really surprised how few questions people ask, and sometimes yes, we might ride on the bandwagon of that, but he told me that he hadn't been fired, that he'd left quite amicably, and that he was still good mates with the founders. So I called the client and I said, listen, I've got two possibilities. I can just call this meeting off and just leave it at that, or I can go and keep it pretty light and maybe assess his desire to cooperate kind of a bit later on. But I think it's giving the client this possibility that can make a real difference. The third risk, and you touched as well upon it, is the risks of civil suits, and I don't think there's kind of much room to kind of go into this. We might touch upon this later on, but I think the bottom line is, as investigators, we have to be really conscious that we can be brought into and we can be used as a deterrent tactic or as a pawn in an investigation, and this can happen anywhere in the world. So we just have to have, I think, this at the front of our minds.
And not just for you, but if you go back again one slide, Bernard.
Which one?
Go back just one. The civil suit that can be brought as a result of breaches of confidence don't fall just to the investigation agency. It also falls to those that hire them, whether that's a subcontractor or, God forbid, the lawyer, or indeed back to the ultimate client. Through the principles of agency, a litigator can make a case live not just against the investigator who sits directly in the underlying unlawful conduct, but also at the lawyers who are hiring them and at the ultimate client who stands behind it. So everybody in the chain has some risk that comes from these new actions. You and I are not any more protected, nor are our clients.
That's the bit I'm most interested in now. So
Is it
how do
now?
the lawyers protect themselves? Screw everyone else.
Ask the question.
Contract. I mean, that's what we learned from the Dangate Consulting case, I'm afraid, is that
Did you say contract?
contract. That's the only protection that falls there.
But is
Had
it
there
enough
not-
just to say don't break the law, don't have GDPR? I mean, is that enough?
Well, actually, I'm not sure that's the point I was making. I think the way that contract protects us is almost an indemnity. In other words, what happened in Dangate is that the investigators made their disclosure to the authorities. The ultimate client was very unhappy about it, went back to the lawyers and said, those investigators you hired, they've gone and told all the secrets I didn't want told to the people I didn't want them told to. And then the civil suit occurs here in the UK. Even though all of these actions happen abroad, the contract is here in the UK, and there's a confidentiality provision. So it's not just the fact that you are you're incorporating terms of lawful conduct into your contract. It's the fact that there are confidentiality provisions in there as well, which effectively indemnify the lawyer should there be a call to action by the ultimate client because of some conduct by the agent, the investigator?
I mean, one thing that we've been, in actually one contract I think we signed recently where we were asked by the lawyers, and and it's set out in our proposal, that we have to be able to justify the investigative process that we undertook to get to the findings we got, So essentially explain and set out this investigative process. And this is in the context of a wider official investigation, so to speak.
You mean you're justifying the lawfulness of your actions? So
Yes.
you say, we are going to do steps A, B, C, D, and these
If
are all lawful
required,
because.
we will have to justify the process through which we got to our findings.
Well, I think scoping can solve a multitude of ills, frankly. I mean, it protects you, the investigator. It protects me, the lawyer. But most of all, it creates a sort of pact of mutually assured destruction amongst all of us. I can't then go and say, you went off and did something which I didn't authorize, and you can't say you didn't, you can't say you were unaware, or that I was acting outside the scope of my authority. Then everybody is, in fact, all agreed and documented up front. If you incorporate that into your GDPR principles as well, in determining that it's proportionate, that it's lawful, that there's a legitimate interest, then that scoping can kind of solve all of the problems in one document. I think we fixed it. We can go now.
That was also managing expectations then. Okay, well, moving on then. I think we heard a number of phrases today. Grey areas was definitely one. Did I hear fluid areas or squiggly areas? I'm not quite sure what the phrases
Fuzzy,
were.
fizzy.
Fuzzy areas, okay.
Orange.
So I'm not sure if this is to you, Joanna, or to you, Gretchen, to talk about the grey areas. There is the use of third parties, there are pretexts, there's surveillance. Who wants to have a go at that?
We'll share it. We'll share. I think, I'll start out with pretext. As we've discussed, and everyone who's been in this industry, it's increasingly, a pretext could potentially put at risk information to be admissible in court proceedings, so it's increasingly not used. At least we really don't use pretext, except for we may approach a person with a slightly different purpose, not completely different, but we'll alter slightly the reason why we're approaching the person. So instead of, that our client is actively an investor in something, we'll be working for someone who's considering an investment in something. So it protects the identity of our client, and it allows us to talk to a person based in a way that we think that person will respond favorably and talk to us. Outside of using all of the old techniques of creating completely false identities, et cetera, we have spent a lot of time developing a network. We really, and I think Joanna has and Raedas, they've done the same. So we have a large network globally that we rely on to make introductions to us. So when we start an investigation, one of the first things we do is look at our network and see who could potentially comment on this matter, provide additional color, or introduce us to someone that we want to speak to. We also use third parties to make approaches for us, but not in a subcontractor sort of manner where we hire another private investigator, but we actually use real companies as cover. So one example is we've used a family office purporting to want to invest in an Eastern European country, and approached the company of which we were tracing the assets, or looking for foreign assets of this company. And under that cover, that person could get a lot farther in talking and having dialogue with the company than we could as Vantage. Rarely do clients really want to take a long-term approach to developing a source, even if that would be the best outcome, because these disputes often last for years. But because people want information immediately or yesterday, if we sat down and said, give us 6 months to quietly and systematically get to know someone and develop that relationship again as ourselves, that rarely works. But that is an option, and it's something that I think is practiced in the industry as well. Do you have any?
It's the use of third parties is, I mean, it has to be much more strategically considered and thought through. And I think particularly when, you know, as an industry, we sort of relied heavily on the pre-transaction work until quite recently. I mean, it was at GPW we did a split of this work. Now we do focus primarily on disputes. And the use of third parties, i.e. people that we're going to hire to be asking questions on our behalf, you know, bears a couple of risks. I mean, again, like I said, there's no control over the information, so people can be, you know, a couple of years ago I was working on a matter, you know, a third party who's a freelance investigator purported to have a load of information and network in this jurisdiction in question, and basically sent me a report, you know, which answered my question 3 days after I'd asked it, which was already you know, this looks a bit iffy. I've been talking to other people, and this was a difficult question. And, you know, I started looking at it and thought, this is entirely fabricated. You know, this guy basically just wrote down, went on the media, pulled a few stories together, and just fabricated these interviews. And the issue there is, you know, we have to be a filter for this, you know, as investigators, because when you're hiring third parties, you have to be a filter for the stuff that comes onto your desk, because it can be a liability by putting it, even if it's not evidence, if it's intelligence, it's going to influence some kind of strategy. And you put it on the desk of your client, whoever they are, and that's going to, you know, have consequences. So, you know, and also I think even on the public record side, we have to be sort of real filters of that information as well. Yeah, I think with what we've done as well, I think a little bit with, I mean, with third parties, again, it's sort of having these kind of strong contracts in place that sort of allow us to trust as well the information. I mean, these are people that we have to know, have to have worked with, and you know, and who will essentially be of use in a situation.
Polly, do you want to jump in on any of this, or should we?
Every time. It seems to me that there's a difficulty here, isn't there? You have this highly regulated industry, the legal industry. We have set qualifications, we have governing bodies, we have rules that we have to abide by, we have rules of court and procedure and of conduct. And then you have another industry which is entirely unregulated and entirely self-governing and speaks in a language that not everybody understands. So you put these two together, and I think you have a recipe for, if not disaster, then certainly some very profitable litigation to flow from it. There is no set guideline for any private investigator. They are governed in this jurisdiction only by their own rules of good behavior and by the civil and criminal law, should anyone happen to find out what they're doing. So everything that lawyers and their clients are believing about the conduct of these investigations comes entirely from the mouths of the investigators themselves, whether they are good, bad, ugly, successful, unhelpful, whatever. We are entirely reliant on what they tell us. I think it's incumbent upon the lawyers who are instructing investigators, especially if they're doing so on behalf of clients rather than the clients bringing the investigators into the case, to make careful and diligent scrutiny of the work that is being done on your behalf. I do not believe that the investigation industry is rife with bad practice and bad conduct, but I do believe it exists there and have seen it many times. So if you are a lawyer in that position or a client looking to instruct an investigator, I think the important thing to do is not accept the smoke and mirrors that might be presented to you, and to ask very specific and particular questions about the material that's being put in front of you, and most critically, the method of its collection. How did you get this? How do you know you got it lawfully? Because if you don't ask that question, your counterparties will.
So you've very clearly laid out, Polly, that the investigators are subject to the standard law of the country, but not a special law. Joana, should you be subject to a special law? Should you be licensed? Should you be regulated? You guys are doing stuff which is, you know, difficult.
I mean, it is difficult, and there are probably, you know, a lot of people in the room that might be better equipped than I am to answer the question on regulation. But I think here it's really a question of fairness and proportionality. And it comes back to my point at the beginning of the session about the different nature and identities and number of people doing corporate investigations. You know, you basically have everything from the big fours that are doing this kind of work to us, to the investigators doing surveillance.
To the psychic investigators.
To the psychic investigators, exactly. So the reality here is we are competing for the same amount of work with a number of different actors, you know, all of which should have to be regulated as well if we are. The second point is you now have law firms as well that have intelligence arms, accountancy firms that have intelligence arms. You know, and these people aren't regulated. They aren't all regulated by the SRA or registered. They aren't all sort of registered with some professional body. They themselves, if they're doing some kind of activity, would have to be included in the bunch. But also, when it comes to recruitment, for example, you know, we are competing with these people to hire the same high caliber people that we want working for us. So we're, you know, at a disadvantage if we can't sort of kind of offer that same playing field. You know, and also in terms of even the kind of the rankings and the credibility that we have, we're being ranked against some of these same people in the same legal rankings. So I guess it's, you know, for us, it's what I think will be really difficult is finding a one-size-fits-all approach, which will basically be able to capture, and Paul, you touched upon this in the lack of definition of private investigations, because the reality is, if I look at my day-to-day work, you know, there is very little of my work that will actually be captured inside that definition, you know. So how does one kind of go about it, and how does one kind of find a blanket regulation that will fit?
That strikes me as a little bit of a distinction without a difference, because lawyers also come in multiple shapes and sizes and flavors, and yet somehow we manage to regulate ourselves and be governed by
Absolutely, but that's exactly my point, is if you are going to regulate, you are going to have to regulate everyone that is doing this work. So
Polly, what would regulation look like to you if you could design it?
That's really unfair.
No, I mean,
I have no idea. I'm sorry. Having spent all those long hours sitting in committees for the SIA, I don't think I got any closer than anyone else. In Slough. Without air conditioning, and I was 8 months pregnant. Yeah, it was not a good summer for me. So rather than take me back to that painful time in my life, Gretchen, I think I would say I don't think it's beyond the wit of man, but because other jurisdictions do license their private investigators and somehow manage to. I think that it is possible to circumscribe an industry if that industry wishes to have a role in what is effectively a very regulated and necessarily so a business. Then if you want a seat at that litigation table, then you accept the rules that we all play by.
Okay, unanswered that one in a way. It's difficult to do, but maybe it will come. We're coming to the end of our time, and so I thought we should end with top tips as to what you should and shouldn't do when using corporate intelligence people, and ask all of you with that. I'll start with Gretchen and then move along.
I think just one point that we've tried to express with clients more recently is to keep the fact that an intelligence firm has been engaged on a need-to-know basis within their organization and within other parties, because we had a situation recently that our name was leaked, not because of anything that we've done, not because it had nothing to do with us, but it was another party became aware of this, and it suited their agenda to leak the fact that our clients had hired investigators. So I think it's, to the extent it's possible, it should be on a very small group of people should know.
I'll probably say it's, you know, to be truthful about what we do, about how we go about doing our work, and essentially when we're sitting in with counsel, to be able to tell them how we did, what we did, and where we did. You know, it's nobody likes to know how a sausage is made. You know, people buy the smell, they buy the taste, they buy the sizzle, but you know, you have to want to know what's in it. And I think sometimes by knowing, and even if things might have been done in a way which could potentially be compromising, you know, by discussing it with the council, you can then decide what to do with it, and you will avoid the concept of a bad surprise a bit further down the line.
Okay.
I'm not giving a top tip. I wanted to extend some thanks to David for asking us to speak on this subject. When Bernard said that we were a last-minute addition, it could not have been more so. We were asked to speak about this just a week or so ago, and cobbled this together as a result of things that had been in the press and I think in all of our minds about what was relevant and important. And I think nothing could show David's instincts better than to say that the case that I think is most topical, relevant, and important right now names no less than 2 speakers at this conference in the filing. So I think, David, you definitely, even from very far away, have your finger on the pulse of what's happening here in the City of London. So thank you very much for asking us to speak and putting the panel together.
Thanks, David.
Thank you, David.
You want to take questions? You want to take questions? I'm very sorry. I think we're coming to the end, and we're a little. I'm being told very clearly that there are no questions from behind you.
The master of all he purveys has just given me the microphone, so you've been overruled. I've got some issues here about the presentation. I'm an investigative journalist, and a lot of people in this room will share these things. We are out on our own as freelancers working for your people, and invariably we're going to get shafted when push comes to shove. Now, going back to the Saab issue, which was raised firstly, Nigel Brown, who was the Dangate man, got convicted of contempt because he did it. He got fined, the cost of £600,000, and it was found that while he was working for the Saabs, he was also supplying information to their competitors in relationship to FNB Bank in Cyprus. Now then, moving on to Iain RC and the writ that you've been waving around with a great deal of electricity. Iain RC hired Marc Hollingsworth to go after their enemies. Then they've turned and produced this Part 7 writ in relationship to him. Now, he will defend it, and a lot of people in this business, well, just hang on a minute, a lot of people in this business will
I don't
help
think
him.
this is a platform for making allegations. We've only referred to things that are in the
Well,
file
you
judgments.
made allegations, and
No,
I'm
I
rebutting
didn't.
them.
I referred to what's in the file judgment, and I think we were all careful to do that. Thank you.
All right, thank you very much for the session.